the Garki branch of the MBA was established in 2023. To the best of my knowledge, I do not know if any other branch has such a committee, but years of legal practice that the then chair initiated this committee, and the current chairman took it upon himself to build on whatever the outgoing chairman has done in this committee, and we have received tremendous support. It will interest you to know that this committee has in time past had webinar on compulsory treatment and care for victims of gunshots Act 2017, which abolished the demand for police reports before victims of gunshots could be treated. At that webinar, we examined the legal remedies available for the victim where that law is violated. We have had webinar on consent to medical procedure in Nigeria. We have had a webinar on consent to medical procedure in Nigeria, a legal perspective. We have had a webinar on medical negligence litigation / the practice and procedure before the Medical and Dental Council Medical and Dental Council Disciplinary Practitioners Disciplinary Tribunal. We have also had webinar on career prospects in medical law practice. So today is one of those days, and we are examining surrogacy practice in Nigeria. It's a 2-day webinar today and tomorrow. We'll be looking at, some of us might be aware, everybody might not be, but to my knowledge, there is a pending bill on surrogacy before the House of Representatives. So we want to x-ray that bill, we want to analyze that bill and identify probable gaps or lacunae within the bill that may not make it an effective surrogacy act when it is passed into law. The purpose of this webinar primarily is to examine that bill and put together a memorandum when the time comes for public hearing, so that we will take a position by saying these are the gaps we have identified. If the bill could be touched here and there, and we have a proper functional surrogacy bill, surrogacy act rather, so that we will not just pass laws that will not be effective or that will defeat the purpose for which those laws were made. So far, we have 32 participants on the call, and by my time, it's exactly 5 minutes past 12. I will just crave our indulgence to grant another 5 minutes time within which we could have more persons. By 10 minutes past 12 on the dot, we will commence the webinar today. Thank you very much.
Good afternoon, everyone. I would like to use this opportunity on behalf of the Nigerian Bar Association, the Key Branch, to welcome everyone for this very educative webinar this afternoon. Just like the chairman of the Medical and Health Law Committee has stated, is the first webinar of the committee, and not just for the committee, also the first webinar for the branch. It had looked like though everything was so quiet, we've not had a branch meeting yet, and then it was important that for the topic that we're going to be dealing with this afternoon, that we grant our members this opportunity, and not just our members, everyone who's interested, this opportunity to be able to learn about the topic on surrogacy, which is not just an emerging topic, but a very relevant one. So I want to use the opportunity on behalf of the branch to welcome everyone, and I also especially want to welcome the lady who's going to be speaking with us this afternoon and educating us on this very important topic. I want to welcome you to our branch, welcome you to the webinar. I commend your efforts so far with the work you've been doing, and I want to say we are proud to be associated with you, and we are open to learning more from you. I also hope this will not be the last time you'll be talking to us. Whenever we call on you, please give us the opportunity to come speak to us and help us get educated. For everyone who will be part of this webinar, I want to say I wish you all a wonderful time as we listen and learn. And let's open our hearts for more learning, because this administration is poised to ensure that our members not just get value for their membership of the branch, but value also in terms of what they will learn to advance their knowledge of the law, their knowledge of the practice of the law, and also expose us all to emerging aspects of the practice of our profession, including but not limited to issues under medical and health law, particularly with the very relevant topic of the surrogacy issues we are going to be talking about. Thank you very much and welcome everyone.
Thank you, Mr. Chairman, for the warm welcome. It is exactly 10 minutes past 1. I know I made a mistake last time when I said 12 o'clock. It's actually 1 o'clock I meant to say. Okay, so far we have 48 persons, 49 persons on the call. We will start in earnest and then we join in the course of time. I can see Madam Gladys Chibuzo all the way from Port Harcourt. Madam Gladys, good afternoon. Glad to have you here. I can see my committee member, Mr. Tijani. Thank you very much. I welcome everybody. In order not to waste our limited time, we will go straight into the webinar and facilitation. Please, we have scheduled time for question at the end of the webinar. At the end of the presentation, you will ask your questions. So kindly put your questions down or type them in the chat box. I will read them out at the appropriate time. Thank you very much. Okay, facilitator this afternoon is an experienced international surrogacy and family law practitioner by name Undiga Emwekwere Mrs. She has, sorry please, she is a seasoned and experienced international fertility law expert of over 25 years post-call, with dual qualification to practice law in Nigeria as well as England and Wales. She possesses over 10 to 15 years practical experience in international surrogacy, transnational child adoption, garment donation, and posthumous conception. She also provides services for families navigating immigration, citizenship, or documentation progress for a surrogate born or donor conceived children. So our facilitator is also the principal and lead consultant at Okamara Law and Consulting, a law firm that is based in Abuja and the United Kingdom, providing services along surrogacy, adoption, and assisted conception. Ladies and gentlemen, for day one of our webinar today, kindly join me and welcome our facilitator, Madam Undiga Emwekwere Esquire. Thank you very much.
Good morning. Can you hear me? Hello?
Hi, we are hearing you.
Okay. I'm just trying to.
Madam, you have.
Good afternoon, everyone, and permit me to stand on existing protocol. I'd like to start by expressing my sincere gratitude to um, the leadership and members of the Nigerian Bar Association Gariki branch, and particularly to my friend and colleague Ebenezer Igwatu. Thank you so much for inviting me to share um, my knowledge and experience with you on surrogacy. I'm just trying to get my slides up. Um, in terms of the structure of my presentation today, I would be saying a little bit about my background, what we're trying to achieve with this particular presentation. I'd like to make a few notes about the scope. I'm going to be focusing on ART, not exactly surrogacy. I'll be talking a bit about what assisted reproductive technologies are and why we actually find ourselves in a situation where we need surrogacy. I'll be talking a little bit about assisted reproductive technologies and the disruptive effect that they have had, and on especially on the redefinition of kinship. And then we'll home in on towards an effective and functional ART act. What functions does that act need to perform, and what is the necessity for such an act? And then we will look at the proposed surrogacy bill and see how it measures up. And then we'll look a little bit about what needs to be done, and then we shall conclude. Thank you, Ebenezer, for the um, introduction. I would like to say a little bit about myself, and which I think kind of will explain my approach. Like Ebenezer had said, I'm an international fertility lawyer with practice rights in Nigeria, England, and Wales. But I qualified and I always identify myself as a Nigerian lawyer because the vast majority of my legal education and foundation was formed in Nigeria. But I did do almost 10 years of lecturing at the University of Essex in the Faculty of Law. And thereafter, I went to Riverbrook Solicitors London, which was where I was actually introduced to fertility law. And while I was there, I was exposed to the fact that there were quite a few Nigerians in the diaspora who were coming to Nigeria for surrogacy and assisted reproduction. And I began to wonder why. So it was actually while I was in the UK that I cut my teeth in fertility law. And the UK is one of the most highly regulated fertility um, jurisdictions that has a very comprehensive fertility law regulatory framework. And so it was on the basis of that exposure in the UK that I actually began to practice infertility law and then eventually decided that I would be based for the most part in Nigeria and begin to um, look at the framework in Nigeria from that perspective. So, in a way, although I'm a Nigerian lawyer, because of my exposure, I had the ability to look at fertility law in Nigeria from the outside in and from an international perspective. So, I like to start my presentation by looking at assisted reproductive technologies. Now, I know that the vast majority of lawyers ended up studying law because they didn't like science and they didn't like maths. But unfortunately, for those of you who ran away from science and maths, we are going to have to deal with a little bit of it in order to understand the legislation. So in Nigeria, we have an association called the Association for Fertility and Reproductive Health, and they have a piece of, what I say, regulation, which is a guideline which has to do with ART. And I like to use the definition from that document, the AFRH guidelines, which defines, sorry, 1 minute. I'm trying to reduce, sorry. Sorry, I'm trying to reduce I'm trying to reduce size, the zoom, sorry, the zoom controls are blocking my view. Sorry, yeah. So I'll just try and continue, but the zoom controls are blocking the my presentation. Let me see. Ebenezer, please, can your back end people see if they can help me, please?
Yes, they will do something about it. They are hearing. Dami, please take charge of this and resolve it. Thank you.
Okay, I don't understand. What's the challenge?
So I'm sharing my screen, but
Yes.
the floating zoom controls are blocking part of my screen share.
Okay, you can share it as a slideshow. You can share it in form of a slide presentation.
Okay,
Just
let me
click on
try that.
slideshow, yeah. So you can play from.
Yeah, I'm still having that I'm still having the
Okay, because I can see a screen from here, so I'm trying to understand. I'm trying to understand the challenge.
you have where you have some of the pictures of the people in the meeting showing it's showing on my slideshow.
Really? Because I can see everything from my hand. I can see the entire slide.
Yeah, but
Same
I can't
here.
see some of my slides.
What you have first here, what I can see here
Okay,
is
okay, don't worry.
lawyers definition.
I'm trying to see if I can hide it. Sorry. Okay, I found it. Thank you.
Okay.
Okay, okay. I think I'm fine now. Hello? Can you hear me?
Yes, we can.
Sorry. Yeah, I think I'm fine now. So yeah, the AFRH guidelines define assisted reproductive technologies as a variety of clinical treatments and laboratory procedures which include the handling of human oocytes, sperm, or embryos with the intent of establishing a pregnancy. Now, these assisted reproductive technologies are primarily designed to help people overcome infertility, the inability to achieve a pregnancy to in order to get pregnant. Now, so these assisted reproductive technology or ARTs include the very commonly known IVF, GFIT, ZFIT, embryo biopsies, pre-implantation genetic screening, embryo freezing, cryopreservation, oocyte and embryo donation or egg and sperm donation, and surrogacy. So, assisted reproductive technologies is an umbrella term for a large number of technologies which together are deployed in order to help people who are struggling to become pregnant to achieve a pregnancy. So that's what assisted reproductive technologies are. And surrogacy is just one of a number of them. So that's the previous slide that I just spoke about was the AFRH guidelines definition of ARTs. But this is my version. This is a lawyer's definition of ARTs. ARTs are a variety of regulated clinical treatments and laboratory procedures, which include the handling of human oocytes or eggs, sperm or embryos, executed in accordance with the law and high ethical standards, properly documented and fully consented to by all the respective parties with the intent of bringing about a pregnancy of an agreed or anticipated contractual specification. Now, the reason why I have this version is because we need to emphasize the requirements of the law in terms of establishing a clear regulatory framework, setting ethical standards, introducing the need for proper documentation, full consent, and also highlighting the fact that all this is
Yeah,
done within a contractual framework and not just a clinical framework that is controlled by clinicians. So, in terms of scope, we're talking about ARTs as the totality of permissible reproductive technologies which are used to overcome infertility and bring about assisted births. And when we say ARTs, we're talking about the totality. And then you can pick out just one of them, which is surrogacy. And I will explain in further slides why I insist on using ARTs as the linchpin of what we're talking about as opposed to surrogacy. So when we're talking about surrogacy, by picking on only surrogacy, we are actually missing the vast scope of what we're supposed to be dealing with. Surrogacy is just one example of assisted reproductive technologies, and we need a framework that encompasses all of them and sets a framework and regulatory environment where all these ARTs are practiced and not just surrogacy. Now, why do we even have ARTs in the first place? We have ARTs because people suffer infertility. And what is infertility? Infertility is the inability to achieve a pregnancy after between 6 to 12 months of unprotected sexual intercourse. And this inability to achieve a pregnancy is brought about by four is brought about is caused by four different things. The first one is we have female infertility factors. Female infertility factors are those things that happen to women which prevent them from establishing a pregnancy. And for the most part, you have uterine factors, which are factors that have to do with something to do with the womb. Then you have ovarian factors, which had something to do with the ovaries, where human eggs are produced. And we have other factors, but these are just the general things. Sometimes you hear about people talking about tubal factors, meaning that there's something wrong with the fallopian tubes, but I don't want to go into too much detail. Then we also have male infertility factors. Male infertility factors refer to those issues, those problems that come from the man's side, which prevent the couple from achieving a pregnancy. And these are sometimes have to do with sperm quality. Sometimes you hear people saying that a man has low sperm count or poor sperm quality. Or sometimes you even hear that a man has no sperm at all. You also have problems with ejaculation or the delivery. So sometimes I tell people that you have the sperms are like the bullets. And then you have the delivery system, which delivers the bullets to where they need to go. And this sometimes you hear people talking about they say they have erectile dysfunction and so on. Sometimes there are problems with the tubes through which the sperm need to travel to enter into the body of the woman during sexual intercourse. All those things together are called ejaculation problems. So you have the male infertility factors, which can have to do with the problems with the sperm themselves, and some of them have to do with ejaculation problems. Sometimes a couple fail to achieve a pregnancy because of a combination of both male and female factors. And then we also have the one which is more heartbreaking, where it's the man is examined, a woman is examined, and there doesn't seem to be any plausible reason why they're not achieving a pregnancy, but they are not actually achieving a pregnancy. And sometimes we refer to those things as unexplained reasons. So assisted reproductive technologies are specifically designed to address one or more of these different factors why people are failing to achieve a pregnancy. So, ARTs are responses to specific infertility problems. Now, we're going to home in on surrogacy. Now, surrogacy is always indicated where there are uterine factors, factors to do with the womb, the uterus of a woman. You remember in a previous slide, I had said that infertility can be due to female factors. And so one of the female factors we talked about is uterine factors. We also mentioned you have ovarian factors. If a woman has problems with her ovaries, she has a problem with the quality or supply of her eggs, very often the doctors will recommend egg donation. If a man has a problem with his sperm quality, very often the doctors will recommend sperm donation. If there is a problem with the delivery of the sperm, but the sperm quality is good and the sperm are actually present, very often the doctors will recommend intercytospasmic sperm retrieval, which means basically they bypass that delivery system that isn't working very well, and they go in and retrieve the sperm themselves and use them for the treatment. But in surrogacy, like I said before, ARTs are a response to specific infertility problems. So in surrogacy, the particular infertility problems that are being overcome are uterine factors, a problem to do with a woman's womb, which makes it difficult and impossible for her to achieve a pregnancy. And some of the most popular, most common uterine factors at play in our environment are fibroids. A lot of people, most people would know either somebody close to them or somebody in their close networks who has reported having fibroids, which are benign growths in your womb, in a woman's womb, which often prevent the woman from being able to achieve a pregnancy. Sometimes there are some women who are born without wombs due to some genetic reasons. But whatever may be the cause, anytime there is a problem with a womb, a woman not being able to achieve a pregnancy because there's a problem with her womb, those are the most of the times when you have the doctors recommending that a surrogacy is used. So, what is a surrogacy? legally speaking. A surrogacy is a contractual arrangement where a woman, also known as a surrogate, agrees to carry a pregnancy brought about by assisted reproductive technologies at the instance of the intending or commissioning parents, with the intention that the surrogate shall, after birth, relinquish custody and all parental rights over the children so conceived in exchange for a legally permissible level of compensation. So, what happens in a surrogacy is that an intending mother, usually more often than not a wife, a woman in a stable committed relationship or in a marriage who has been told by the doctors that she has some uterine infertility factors and who under medical advice has been told that the only way that she can bring about they can achieve a pregnancy is if somebody else, a surrogate, carries the pregnancy for them. So the parties now enter into a contractual arrangement with the surrogate, who agrees that she will submit herself to fertility treatment, to the administration of assisted reproductive technologies at the instance of those people. And the intention of that contractual arrangement is that this surrogate is going to deploy her gestational capabilities. She's going to allow her womb to be used to gestate a child. And after the birth of that child, this surrogate agrees in a contract that she's going to relinquish custody. She's going to give that child to the intending parents. And then she's also going to conclude all the necessary administrative and legal processes to allow the parental rights that she should otherwise hold be transferred to these intending parents. And in exchange for all of this, she will receive a legally permissible level of compensation. Now, why do I qualify it as a legally permissible level of compensation? Because in countries that have assisted reproductive technology laws or fertility laws, there's always a provision or there's always an attempt to control the level of financial compensation or money that is exchanged in a surrogacy. In some countries, it's a laissez-faire situation where the government or the state is not interested in the level of compensation, even if the parties agree that they're going to exchange millions of dollars of pounds of dollars or pounds. It's not a matter for the state, but it is a matter for the state to the extent that the state says that, well, if this is what is the intention of the parties, it is legally permissible. In some other countries, they have a different approach. The state would say, in any event where there is a surrogacy, we shall have the power to control the level of financial recovery. Countries such as the United Kingdom, where they try to control the financial recovery in surrogacy, and in the UK, for instance, you're not allowed to, the payments that are made to the surrogates must be approved by the court. So that is what is legally permissible in the United Kingdom. But in any case, in any country where you have fertility laws, the state will always say, well, if it is commercial surrogacy, you're allowed to set any level of compensation. But if it's altruistic surrogacy, the state has controls over the level of compensation. But it's always, the level of compensation is always legally defined by the state. So the surrogate agrees to provide gestational services and stands in the stead of the intending mother who is incapable of carrying a pregnancy herself. Now, the surrogate may or may not be genetically connected to the child or the children that she's carrying. If the surrogate provides her egg and her egg is used for that pregnancy, we say that it's a traditional surrogacy, in which case the surrogate was also the genetic mother of the child. That's what a traditional surrogacy is. But if the egg that is used to achieve the pregnancy comes from the intending mother or an egg donor, we say that it is a gestational surrogacy, meaning that all the surrogate is doing is providing gestational capacity to bring about the pregnancy. So that is what we call a gestational surrogacy. Now, it is the the fact that the pregnancy is brought about by artificial means, by assisted means, the fact that the pregnancy is brought about through the use of assisted reproductive technologies as opposed to sexual intercourse, this is the defining line between modern surrogacy and surrogacy as it exists in many African and other cultures. It would be interesting. It's interesting. A lot of people do not know that there are very many ethnic groups and cultures, not only in Africa but in other parts of the world, where some kind of surrogacy exists and has existed for millennia. Now, very often when people are talking about surrogacy, the first example they mention is the case of Abraham and Sarah and Haggai in Genesis in the Bible, where the patriarch Abraham was having problems having a child with his wife, and then they brought in the maid of his wife to carry a child for him, who carried the child Ishmael, who is considered the founding father of the Arab tribes. So, apart from the biblical example that I just mentioned, there are many cultures, even in Nigeria, where you have a situation where a woman who is married or who wants to have children, who cannot have children, and another woman is brought in to help her to have a child. So, although the word surrogacy is not used outside Western cultures, the practice, the essence of the practice itself, our assisted parenthood, using a woman to help another woman have a child is something that is not very uncommon. But the reason why modern surrogacy is different from these practices is the fact that there is no sexual intercourse involved. The pregnancy is brought about by clinical means. So, if we look at surrogacy in terms of breaking it down, having a deep dive into what is actually happening, you have on the one hand the gestation or the pregnancy, the fact of carrying the pregnancy on the one hand. And then on the other hand, you have genetic contribution in terms of whose eggs are being used to bring about this pregnancy, whose sperm is being used to bring about this pregnancy. And then you also have on the side of the gestation and the pregnancy, you find that for as long as human beings have procreated and had children, you've always had the situation where the social recognition and the legal recognition of the fact of motherhood in particular has always followed pregnancy and gestation. So if you look back, because a lot of people ask me, oh, why do you say that the surrogate is always the legal mother of the child? Why do you say that it is judicially noticed? Why do you say that it's a founding principle that has never been litigated upon? It's because before the advent of assisted reproductive technologies, we never ever had a situation where people ended up in court and were trying to find out who the mother was. There was always a very simple way to find out who the mother of a child was. We tried to identify who carried the pregnancy. And in the few cases where the question of who the genetic mother of the child was, in a few instances, you'll find where a court will order for DNA testing to be done. But for the most part, DNA testing has always been used to establish who the father of the child was, because by general knowledge, the mother of the child was always the person who carried the pregnancy. And so the social recognition of who the mother was followed the biology of the fact of pregnancy. And the legal recognition of who the mother was also followed biology. It followed the fact of who was the woman who gestated this child, who was the woman who carried the pregnancy, and that woman alone was always recognized socially and legally as the mother of the child. And so we had in every context, before you had the advent of assisted reproductive technologies, we had default parenthood rules. So just imagine that you walked into a supermarket or a store and you bought a computer. That computer will come with certain settings already in place, default settings. The same thing applies to parenthood. Before we had all the complications and the disruptions of assisted reproduction, we had default parenthood regarding who the mother of a child was and who the father of a child was. So in terms of motherhood, motherhood was always assigned by pregnancy, by gestation. So, by extension, the surrogate is always the legal mother of the child. The starting point of every surrogacy in any legal system is that the surrogate, the woman who actually carries the pregnancy, is always the legal mother of the child. And then subsequently, the legal system can put into place structures and procedures and processes where motherhood is reassigned. But the starting point is always that the mother of a child is the woman who carries the pregnancy. That woman who does the 9 months of morning sickness, the stretch marks, the pushing, the breastfeeding, etc., that woman is always the legal mother of the child. Now, the fatherhood of the child was always a little bit less straightforward. But for the most part, if you look at the legal systems of the different parts of the world, fatherhood was always by identification and acknowledgement. Somebody is found to be pregnant, and the lady who is found to be in the family way, who is responsible for your pregnancy? It's Okechukwu. Okechukwu, are you responsible for this pregnancy? He says yes or he says no. If he says yes, that's the end of the problem. But if he says no, then things get a little bit more complicated. Now, in all the legal systems of the world, fatherhood, parenthood was always considered to be protected when it happened within the confines of a legally established marriage, or what we call affiliation. So if there was an existing relationship of a specific kind, usually a marriage between a man and a woman, every time the woman gave birth, there was a presumption of fatherhood that the man, the spouse of the woman who carried the pregnancy, would always be the father of the child. Now, these existing default rules are always there in the background. And then you now bring in the assisted reproductive technologies into the fray. So, one of the things that we always have to ask ourselves is, considering the existing default rules relating to motherhood and fatherhood, how is the legal system supposed to respond when you now have a situation where pregnancies are brought about by assisted means, and that an egg can be donated by somebody else, a sperm can be donated by somebody else, a pregnancy can be carried by somebody else, in a some people who are different from the intending parents. These are things that um the rules, the laws have to address. Oh, please, I'm having some trouble. Okay, so we always say that one of the problems that we have with assisted reproductive technologies is the fact that it brings about a redefinition of kinship. Now, assisted reproductive technologies have completely redefined how people reproduce and how you define the relationship that exists with people, between individuals. So, on the one hand, we have gamete donation, a situation where if somebody has a problem with their sperm, they can get a donor sperm. If somebody has a problem with their eggs, they can get a donor egg. How do you redefine the relationship? What does it mean to be somebody's mother or somebody's father in the presence of gamete donation? It completely scrambles the idea of what it means to be somebody's genetic parent. Is a genetic parent, can you consider somebody who donates their egg or their sperm to be a parent or not? Another issue that comes up is, if all along, from time immemorial, we have considered that a mother is somebody who carries a pregnancy. So how do we square that with a situation where a woman, a surrogate, agrees to carry a pregnancy or provide gestational services under a contract, is she a mother or is she something else? And then what happens to the person at whose instance that surrogacy contract is initiated? And we also have another issue that deals with the issue of the social recognition of parenthood and the contractual intention. In a surrogacy, an intending parent or intending parents enter into a contract with the intention that a child carried by the surrogate should become their child. But however, society only recognizes as a mother the woman who actually carries the pregnancy. And now you begin to understand why a lot of people who go into surrogacy contracts, they actually use artificial baby bumps to pretend to be carrying the pregnancy themselves, so that when the child born by a surrogate is born, that society will accord them that social recognition of parenthood that they have always craved. And then you also have to consider the question of the legal status versus the biological reality. Now, under the contract, the intention of the parties, the intending mother, the intending father, and the surrogate, is that the child should be considered for all intents and purposes as a child of the intending parents. But the biological reality points in a different direction. The biological reality points to the fact that it is the surrogate who is actually the mother of the child. And so when you put all these issues, when you put all these problems together, these are the reasons why people consider the use of assisted reproductive technologies and particularly surrogacy highly problematic, both legally, ethically, culturally, and otherwise, because it kind of completely upends everything that we have always known from time immemorial about what it means to be somebody's mother, what it means to be somebody's father, what it means to be related to somebody else. These are the issues that need to be tackled very carefully, very consciously by any assisted reproductive technology laws or surrogacy laws. So if we look in carefully and at assisted reproductive technologies and the redefinition of kinship, who is a parent? So let's meet the contenders. The biological parents. The biological parents are the people who supply the eggs and sperm. And if you look at it from that perspective, a sperm donor or an egg donor is a biological parent. But if the intending father or the intending mother actually provide the eggs and sperm that is used for the treatment, they will be the biological parents. But how do you square that situation where there's an ovarian issue and a donor egg has to be used? How do you square that situation where the man has no sperm or he has sperm quality issues and a donor sperm has to be used? And remember that in our legal system, we have always said that in order to establish genetic origins, we ask for a court order to ask for a DNA test to be done. If a child is donor conceived, that DNA test does not solve our problem because it points to the egg donor or the sperm donor. It will not map to the intending mother and the intending father. So this points to one of the reasons why we need a law. Who is a birth mother? A birth mother is always the woman who gives birth, whether it's a surrogate or the intending mother, whether or not the person has used her egg or not. So even if the egg came from the intending mother or the egg came from an egg donor, because of the ways our laws, the default parenthood rules work, that surrogate will always be considered the legal mother of the child, whether or not she has genetic contribution. So the intending parents and the commissioning parents, these are the people who are actually paying for the treatment. These are the people who have entered into the contract to say, we would like a child to be born. They are also contenders. Who are the social parents? The social parents are the people who are recognized by society as being the intending parents, to being the parents of the child. So if a surrogate is seen out and about, pregnant, once she gives birth to the child, there will be immediate social recognition that she is the mother of the child. So that is a problem that needs to be addressed. But then again, we also have legal parenthood. Legal parents are the people who are recognized by the law as being the legal parents of the child. So if you look at the number of options, you begin to understand why we say that assisted reproductive technologies are have been highly disruptive in terms of the definition of kinship. So, how exactly is surrogacy considered under Nigerian law as it currently stands? So, I always say that yes, we don't yet have any fertility laws or surrogacy laws or laws regulating surrogacy in Nigeria, but the practice is affected by existing laws, the laws that we've always had on in our law books. So yeah, so although important aspects of surrogacy have not yet been directly legislated upon, they are covered indirectly by existing laws. And I've just explained what I mean by that when I talked about the default parenthood rules. Now, it even gets a little bit even more complicated when you have international surrogacy, where you have intending parents live in one country and they move to a completely different country, often a country like Nigeria, for fertility treatments, and then they intend to take the children brought about by the surrogacy to the country outside Nigeria to live in. And so in a lot of those in those cases, you find that the the country of residence where the parents live and where they intend to raise their child, the laws of those countries often have extraterritorial effect. So in terms of, for instance, if if intending parents live in the United Kingdom, for instance, and they go to Nigeria or any other country in the world, for that matter, for fertility treatments, the laws regarding surrogacy and assisted reproduction will apply to them as long as those children, those surrogate born children or donor conceived children, are going to be brought back into the United Kingdom to live. And the same thing applies to very many other countries. You find a lot of Nigerians in the diaspora who come to Nigeria for different reasons, for surrogacy and fertility treatments, and they intend to return to the destination country or the residence country to live with their children. And so in those kind of cases of international surrogacy, you find out that it is actually the destination country or the resident country that plays a controlling part in terms of defining the criteria, the documentation, the procedures, who is recognized by under their laws as being the legal parents of the child, the legal mother of the child, the legal father of the child, and what needs to be done for those children to be taken out of Nigeria and into those countries. That gives an extra layer of complication. So under Nigerian law, for instance, some of the problems that we have with surrogacy is, like we have mentioned, is that we do not yet have existing legal frameworks. But our courts have treated surrogacy contracts just like any other contract. And some of the problems that affect other contracts also affect surrogacy contracts. And one of them is the question of unequal bargaining power and freedom of contract. In order to solve the problem of how do we figure out what to do when there's a surrogacy under in Nigeria, our courts have been very good at applying contractual principles of public policy, good conscience, and fairness. They also apply other principles such as duress, undue influence, unequal bargaining power. But the problem is that in the absence of a clear legal framework, you get very variable results. Sometimes you're before a judge who has very deep ethical concerns, as they should, about surrogacy, and they're not even willing to consider that a surrogacy should be the subject of a contract. And so you will get a very unfavorable outcome. But if you went to a different court, a different judge before in a different jurisdiction or somewhere else, with somebody who has a different mindset, you would get a different result. And so it leads to a lot of legal uncertainty on the part of the parents, on the part of the surrogates, and so on and so forth. But The truth of the matter is that the judges are doing the best that they can with the tools at their disposal. Another issue is that we have the uncertain nature of the surrogacy agreement. There's been a lot of judicial activism. Lagos seems to be, in the forefront of that. But we also know that children is a very sensitive area of our law, and they are covered extensively under existing legislation. We have the constitutional protection against discrimination based on the circumstances of birth, which has been very highly litigated. We have best interest protections that are coming to play in adoptions, etc. We have the Child's Rights Act. Particularly, we talk about Section 14, which talks about parental care and the prohibition against children being separated from their parents. And then you begin to think about the things that are happening under surrogacy, and you begin to understand why we really need a very comprehensive legal framework. And then we always get into arguments about Section 30, and I also think Section 50 and 54 of the Child's Rights Act, which prohibits, there's a blanket prohibition on the buying, selling, hiring, or otherwise dealing in children. So the question I always get asked is, given the fact that in the surrogacy agreement, there is an exchange of money or financial compensation between the surrogate and the intending parents, are we actually dealing in gestational are we just dealing in, is the subject matter of the contract gestational services, or are we buying, selling, or hire, or otherwise dealing in children, which would bring us under the prohibitions of Section 30? That's a very common question I get asked. Now, another issue that we also need to deal with is determining the parental status among competing parties. Remember that we talked about the default parenthood rules, and we said that the surrogate remains a legal mother until parental rights are effectively transferred. Another effect of the existing laws that we have is that if a surrogate is married, her spouse automatically becomes the legal father of the child. And we have Section 165 of the Evidence Act and all these cases that which I know many of you will be very familiar with, which point to the rebuttable presumption of parenthood within marriage. And you have to understand that there are very, very deep and powerful public policy reasonings behind the prohibition of being able to compel somebody to provide evidence of being an illegitimate child. And these are very deep ethical concerns, which also affect the treatment of surrogacy cases by our courts, especially in the absence of clear legal guidance and provisions regarding the practice. And as we currently stand in Nigeria, the only available mechanism for the termination and transfer of parental rights is adoption. Remember that we said that in a surrogacy that the parties, the intending parents of the surrogate, enter into a contract whereby the surrogate will carry a pregnancy with the intention that the child will be handed over and parental rights over that child relinquished in favor of the intending parents. Now, a lot of people run into trouble because some people seem to think that that surrogacy contract in itself actually accomplishes the objectives of reassigning the motherhood of the surrogate born child and allocating it in favor of the intending parents, and also terminating the legal status of the surrogate as the legal mother of the child. Now, if you go through our laws, you will find that there is no provision in our laws and in the laws of very many countries, and for very good reason too, for the parenthood of an individual to be reassigned by private contracts. And I'll say that again for the people at the back who will come after me with arguments. There are very serious ethical, legal, and moral reasons why in almost every legal system of the world, it is impossible for you to terminate, reassign, or reallocate parental rights over a child by means of a private contract or agreement. It's not possible. The reallocation, reassignment, and termination of parental rights in almost every legal system of the world has to be done through a court-mediated process. And as things currently stand in Nigeria, the only mechanism available for doing that is an adoption order or a similar order. So you also have examples of the Births Compulsory Registration Act in Nigeria. If you read that act, you would see that there is an underlying, it's impliedly included that a mother is always the woman who gives birth. And when the registration of the child is being done, the registrar of births relies on the information provided by an informant, which might be an imam, a midwife, a doctor, a clinic, and they include an entry making a public record of the birth. The registrar of births makes an entry recording the birth, relying on the information provided to them. And the implication is that the mother whose name is put on the record is the woman who gives birth. And there's no provision in our laws for surrogacy. So this is another area that needs to be addressed by any assisted reproductive technology law or surrogacy law. Now, one of the other things that has to do with surrogacy that needs to be dealt with is the fact of unequal bargaining power and contractual freedom. We all know that in Nigeria, for the most part, people who go into surrogacy, people who volunteer to be surrogates are doing so because of financial reasons. So we always have to have, as lawyers, we should be worried about the question of unequal bargaining power and the fact that if somebody is so poor that they're considering entering into a surrogacy contract, do they really enjoy contractual freedom? Are they really in a position to bargain to get themselves a fair deal or not? Can we safely say that the existing rules that we have in relation to incapacity, fraud, duress, undue influence, and deceit, are these rules sufficient for use within the specific context of surrogacy? And what do we do in order to distinguish these legitimate practices of surrogacy from baby factories? We need to think very carefully about consumer protections. And when we're talking about surrogacy contracts, what are we talking about? Are we talking about a contract for the supply of goods or services? Or are we talking about a completely different genre of contracts, which don't fall under the traditional dichotomies, which we are already used to as lawyers? How do we begin to think about unfairness in terms of contracts? Are we talking about the substance of the surrogacy agreement itself? Or are we talking about the procedure and the process which has brought this contract, this agreement into existence? Should we be worried about the quality of counseling that the surrogate has received? Should we be worried about the fact that she was given proper information as required under the National Health Act? Or should we be thinking about something over and above what we're looking at? Should we be worried about informed consent? Should we be worried that the surrogate never had her own lawyer to advise her before she went into the contract? Should it be adequate that the lawyers for the intending parents or the hospital's lawyers were the only people that advised all the parties to the contract? Should it be something of concern? Should we be so concerned about it that it's something that we should legislate about? Should we also be worried about preventing what is called the commodification of reproduction? When we consider the family as a primary unit of society, and that children are very often the focal point of many public policy and ethical concerns. Should we be worried? Is this something that should be reflected in our legislation? Should our legislation be reflective of the fact that we have very high poverty levels, the lack of effective regulation, that we have a lot of exploitation involved in assisted reproduction, and that we have existing issues with baby factories? How about Section 30 of the Child Rights Act? Should we be looking at the experience of countries like India and Thailand and so on? And how will judicial practice need to change in the light of all these problems that we're talking about and in the light of the potential regulatory framework? So the idea behind all the information I've given to you up till now is to give you some enough background information about the context, about what assisted reproductive technologies are, what they do, and the problems that they cause. And the objective behind giving you all that information, because I'm sure some people will be wondering, why is she taking us through this wrong, scenic route? The reason why I gave that background is for you to begin to understand what an effective and efficient assisted reproductive technology law needs to be doing. What objectives should it be achieving? What exactly should we be looking for in such a law, or rather, for our particular purposes? What are the things that we need to put into an assisted reproductive technology law that would make it effective and efficient? Now, to my mind, one of the first things that such a law should do is it should set these practices on a clear legal footing, or what I call legitimization. Because right now, it's in limbo. It's in a lacuna. It's in a blind spot in the law. Our laws were created and promulgated before we had assisted reproductive technologies. So we need the law to come out and say, okay, surrogacy, ZIPT, IVF, gamete donation, etc., etc., they are permissible, they're legally permissible under 1, 2, 3 conditions. We need that clear, predictable legal footing so that we know exactly what we're doing. We need the law to provide legal certainty. The laws need to provide for recognized departures from the default parenthood rules that I've just discussed, about the established procedures, qualifying criteria. Is it just anybody that can do surrogacy? Is it just anybody that can step up to the plate and offer to be a surrogate? Is it just anybody that can say, I want to have a child through surrogacy? Must there be medical criteria? Should there be criteria relating to marital status? Should there be psychological screening? Is it just anybody that can drop into Nigeria and say, I'd like to use a Nigerian surrogate? Should there be eligibility criteria based on nationality? Should we be looking at the criminal records of people who want to do surrogacy? These are all different things that are very worrying, and there are varying approaches that are taken by different countries all over the world. We should be thinking about, an ART law should be thinking about protections of the parties. For the reasons I've mentioned before, there should be some very solid protections put into any ART law for surrogates to prevent their exploitation for the reasons we've discussed. The intending parents themselves also need protections. What about the gamete donors? What about the surrogate born and donor conceived children? And we also need to consider the protection of societal values and ethics and other norms. So it's not just, yes, although it might well be that infertility is deeply personal, but in the long run, it's a social issue. Yes, a man and a woman in a relationship, or a single woman or a single man who wants to have children, might be thinking that this is a deeply personal and distressing situation. But in the final analysis, it's also a social problem. And the way in which we address infertility by assisted means and otherwise is a very fundamental social issue in my mind. So What are the other things that an assisted reproductive technology law should do? What should it be doing? It should provide data protection and information rights. Now, this is one of the very deep, one very contentious area regarding surrogacy. So on the one hand, you have the egg donors and the sperm donors and the intending parents. They have very heightened needs for confidentiality. Oh, we don't want anybody to know the circumstances under which this child was born. Oh, we don't want anybody to know that there was an egg donor or a sperm donor involved. The egg donor and the sperm donors are like, look, I did this because I wanted to help somebody or I wanted to make some money. I don't want in 18 or 20 years time somebody knocking on my door and say, hello, you're my dad, or hello, you're my mom. I want complete anonymity. But on the other hand, we have to consider the interests of the one person who is not in the room to advocate for themselves. And that's the surrogate born child or the donor conceived child. And there is a very big movement that says that the knowledge of one's genetic origins, who is one's genetic mother, who is one's genetic father, who is somebody's birth mother or birth parent, that it is an integral and important part of a person's identity rights. So a person is not able to form, under that argument, a person is not able to form a complete perception of their identity if certain aspects regarding their certain information regarding their genetic origins is hidden. And so that there is no justification under which the identity of an egg donor or a sperm donor should be hidden in perpetuity from a donor conceived child. And so under that argument, a lot of people are saying that when just the same way that an adopted child can ask for the unsealing of a public record or adoption records when they turn 18, that a donor conceived child should have similar rights to find out who their genetic parents are. And that comes with all kinds of complications because there's a very big worry that perhaps if people knew that their identities will be disclosed, that they probably might not be interested in becoming egg donors or sperm donors. And then we also have to consider the issue of our specific context in relation to our culture and the very deep-seated concerns we have about the ability to trace your lineage. In every culture, there will be some adage or proverb about the importance of a goat knowing the way to his house, or the importance of knowing who your kith and kin are. How does that sit with the very um, deep-seated desires of intending parents who, for instance, who have problems with eggs and sperm, who are unable to have their own genetic children? Can we, as a society, deny them the ability to have children using donor egg and donor sperm, technologies that are freely available and accessible? Do we have the right to deny them the use of these technologies to satisfy their yearnings to become parents just because we have traditionally always defined kinship in terms of blood? Is kinship only about blood and genes? Is kinship more than blood and genes? Is it possible to be somebody's child? Is it possible for you to adopt a child and that child becomes yours in every sense of the word, except through DNA? These are difficult questions that don't have easy answers, but which are implicated very seriously when we begin to talk about surrogacy and assisted reproductive technology. Because surrogacy is just one side of the coin. Surrogacy talks about who carries the pregnancy, but also you also have the question of whose genetic material is used, whose egg was used, whose sperm was used. And then you now begin to talk about who carries the pregnancy. Another thing that a good ART law should do is to provide a recognized departure from default parenting rules, procedures, and so on and so forth. I think this is a duplicator slide. Now, we just looked in brief summary at what a good ART what should be some of the things, the highlights of a good ART bill. So let's look at the one that we have right now, the Alao Akala Surrogacy Bill. In my view, it's a good start, but because I am aware of what other countries have done and what the contents of a good ART bill should be, my view, remember that this is my personal view. I do have some affiliations with some professional bodies, but this is my personal view. I believe that bill is a good start, but I have a number of issues with it. And the good thing about it is that these issues are things that can be easily addressed, but it is not something, this bill, I think, is not the kind of bill that needs to be rushed. We need to take our time and begin to pick things one after the other to make sure that we get a bill that is not just efficient, but also suitable for a particular context. Because Nigeria is a peculiar place. So you can't just pick up a bill from some other country and bring it here and expect it to work. We need a homegrown solution that recognizes our economic, social, and legal context, and which comes up with solutions to address the different challenges that are raised by assisted reproductive technologies and surrogacy. So one of the first things I would say about that bill is that it's not comprehensive enough. I don't know what has informed the focus on surrogacy, but I'm sure if you had been following my presentation from the beginning, you'll begin to understand that what we need is an assisted reproductive technology bill and not just a surrogacy bill. Now, when a new bill is brought into existence, when a new law is being planned, it's a law reform project. And a law reform project can be on different scales. Sometimes one or two provisions of a law might need amendment. Sometimes a whole law might need to be repealed. But I think the most extensive and most demanding form of legal reform is a situation where a completely new bill is brought into existence where none existed before, and which would require extensive amendments and repeals of existing legislation. And to my mind, this is the kind of legal reform project that we're looking at with an assisted reproductive technology or surrogacy bill, whichever one you call it. It's quite an extensive piece of work, which I'm not sure a lot of people really appreciate. So if you look at it from that perspective, we've already mentioned a number of pieces of legislation that will be affected by this bill. And we talked about Section 165 of the Evidence Act. We've talked about Section 30 of the Child Rights Act. Even the NAPTIP Act, the Civil Registration Bill, the Evidence Act. There's so many different pieces of legislation scattered in so many different places that will be affected by the enactment of an assisted reproductive technology bill. And none of these pieces of legislation are reflected in the bill that we currently find making its way through the House of Representatives. It is worrying. Now, in terms of another aspect that I am worried about the present bill is how it has handled the question of parental rights. Remember that I spoke earlier on about default parenthood rules. There need to be some very cast iron solid provisions about how parental rights are allocated when there is an egg donation, when there is a sperm donation, and when there is a surrogacy. Who qualifies to be the legal mother of the child? What processes and procedures need to be followed in order to ensure that this particular person becomes the legal parent or that particular person becomes the legal parent, or the process of terminating the status of the surrogate? as a legal mother of the child. We need to talk about things about, is it just anybody who qualifies to be an intending parent by surrogacy? Can a criminal apply to be a parent through surrogacy? Can a convicted felon tell a sex offender? There are all kinds of things. What are the qualification criteria for intending parents? Similar to with surrogates. Do you just qualify to be an egg donor or a sperm donor just because you are biologically capable of producing eggs or sperm? These are things that we need to consider very carefully. How are parental rights acquired? What is the role of the courts, and welfare services, and so on and so forth in surrogacy, in terms of screening, in pre-qualification, and so on and so forth? Are we talking about a pre-birth order where you need to get the authorization of the court before you start the process, as happens in places like South Africa? Are we talking about a post-birth regime, like what happens in the United Kingdom and many other countries, where you approach the courts and start the process after the birth of the child? What are the roles of the surrogacy agencies? Are surrogacy agencies allowed to operate on a commercial basis or not? Are surrogacy agencies required to be registered, and by who? What are the conditions for their registration? What are the regulatory frameworks for the regulation of surrogacy agencies and egg donors and sperm donors? Who takes charge of them? What about the fertility clinics? What about the so many garment brokers, people who neither identify themselves as fertility clinics or surrogate agencies, who go about arranging for the buying and the selling of eggs and sperm? These are a lot of things that need to be considered. They are considered in a very peripheral way. Surrogacy agencies are mentioned in the Allow Color Bill. In one section, it says that we are not allowed to, no person or entity, I think section 9 says, no person or entity shall offer or receive any payments, benefits, or consideration in exchange for arranging a surrogacy, acting as a surrogate, or entering into a surrogacy arrangement. That's section 9. But section 7 of the same bill says, which says that it is permissible for surrogacy agencies to be registered and operate in Nigeria. So right there in the bill in itself, you have a clear conflict between section 7 and section 9, which needs to be clarified. So I think that there's also no talk about who qualifies to run a surrogacy agency and so on and so forth, the conditions under which they will be allowed to operate. And so I think there's been there's this, I mean, I can't deny the fact that there's been progress. The fact that that somebody actually sat down to begin to think about a surrogacy bill, they need to be commended. But there's a lot of work to be done. We also have the question of inadequate protections. I'm very worried, especially given our particular context, of the fact that there doesn't seem to be a lot of thought about how we prevent the exploitation of surrogates in Nigeria by people who obviously have a lot more money than they do. Um, there is, I think in section 14, it says that, I think in section 13, it says that there must be medical evaluation and mental evaluation. But mental evaluation, they say a mental evaluation, it has to be done by specific kind of professional with specific kinds of qualifications, which are not really detailed. Now, I would like to see a situation where there is mandatory requirements for the provision of information and counseling by qualified professionals. So a qualified clinical psychologist, for instance, or a counselor should be it should be a mandatory requirement for anybody who goes into a surrogacy, for a surrogate to receive counseling by such a person and evidence.
Security.
Sorry? I'm hearing someone. Is someone addressing me?
Oh, sorry, ma. I've muted the person. Sorry.
Okay. So yeah, so I'd like to see provisions about adequate information and counseling by qualified professionals, particularly for surrogates. And I'm sure the lawyers here will be very happy to hear. I think it should be a mandatory requirement that every surrogate should have independent legal representation paid for by the intending parents. Because a situation where one lawyer who is paid for by the hospital or paid by the intending parents also advises the surrogate, or the situation where the surrogate receives no independent legal advice or representation at all is highly worrying for me. There should be clear documentation requirements. And then also another aspect of that bill that worries me is the abuse of notarization. In Section 14, it says that the presence of a notary public at the point of signing of the surrogacy agreement will be considered to be evidence of the fact that the surrogates and other parties provided informed consent. Now, it's very important to note that in the surrogacy agreement, we're not just interested in signatures. We're interested in informed consent, which is the consent that has been given, the kind of consent envisaged in the National Health Act, where a party freely and willingly accepts to the administration of a medical procedure in full knowledge of all the risks, advantages, and benefits and dangers of that medical procedure. That is what we're looking for in surrogacy, informed consent. Now, those of us who are notaries public, sorry, will know that the objective of notarization is for the notary public to attest to the fact that a particular individual attached their signature to a document. But even though notarization is useful in surrogacy, that is not really what we're looking for. What we're looking for is informed consent, which is the psychological preparation that happens before a person appends their signature to an agreement. And for that to happen, we need two things. We need independent legal advice and proper counseling. So for me, it's very worrying for me to see somebody trying to use notarization as a proxy for informed consent, because it means it appears to me that that person doesn't really understand some of the fundamental issues that we are trying to address in surrogacy. So I seem to have lost, I can't find my timer, but I'd like to stop here by saying that I think there's a lot of good um that has been done in this act. But for the reasons that I've outlined earlier on before, I think that there's still a lot of work to be done. Um, I think as lawyers, we have a duty not just to earn a living, which is very important, but we also have a duty as officers of the court to protect the integrity of the law and by extension, society whom we serve as officers of justice. And so I think there's a very important role that needs to be played by lawyers and other well-meaning Nigerians to make sure that any law that is passed regarding assisted reproductive technologies and surrogacy must be something that's been very, very carefully considered. We need broad stakeholder engagement. We need a very careful consideration of our own particular context and the objectives that we're trying to achieve. It's not something that can be done in a hurry. It's not easy.